So today we're going to talk about, more than anything, updating your Advance Directive. And so in that regard, one of the problems is that we have Advance Directives that are in themselves problematic. And let me go forward here just a second and talk about this. You know, the number one fear worldwide is public speaking. The number two fear is talking about death. So if you take that to its logical extension, if you go to a funeral, you're probably more comfortable in the casket than delivering the eulogy. And that tells us as much as anything about how difficult conversations about death and dying are. Woody Allen had once said, I don't mind being dead, I just don't want to be there when it happens. He is correct, and the kinds of concerns that we have come up regularly. For example, my mother, who died a year and a half ago, many years ago, was at her doctor's, and she was very concerned that she was going to die of cancer. She said to her doctor, well, you know, my mother died of cancer, my father died of cancer, and it just seems to be running in my family. I am extremely concerned about dying from cancer. To which the doctor had replied, so Betty, would you rather a truck hit you? And in thinking about it, she kind of thought, well, maybe that's not too bad. But if you think about being hit by a truck, instant death isn't guaranteed, and particularly in this day and age, even after you're dead, clinically speaking, you can be revived, put on machines, and left to live for years at a time. The initial case that really demonstrated the need for advance directives was the Nancy Cruzan case. And in 1983, January 11th, 1983, Nancy was driving home from a night shift at a high speed in rural Missouri. And somehow she flipped the car and ended up dead in a ditch. Clinically speaking, she wasn't breathing, she had no heartbeat. And in fact, officers that were responding walked past her, assuming she was dead, but because there was a child seat in the car, they started looking for a child. Imminently, one of the officers called 911. They didn't have 911 back then, but called emergency services, got the ambulance there. They were able to perform CPR, and Nancy was revived, so to speak. That is to say, they started her heartbeat and her breathing and transported her to a hospital. To cut to the long story short, Nancy, like Karen Ann Quinlan and Terry Schiavo, was in a coma for 8 years, during which time her parents were desperately trying to have the one thing that was connected to her, her feeding tube, removed because they knew she didn't want to live that way. But because there was no documentation as to what her desires were should she find herself in a state like this, no indications of the quality of life or anything along that line, the courts refused to let the feeding tube be removed. Ultimately, it went to the Supreme Court, and ultimately she did get her feeding tubes removed, but that resulted in the Patient Self-Determination Act of 1991, which really mandates that you have an advance directive if you want anything other than life-sustaining treatment at the end of life. And we'll talk more about that. So the question is, what is the idea of a good life for you? And many people, like my mother, want to die, as Bob Monkhouse says, I want to die like my father, peacefully in a sleep, not terrified and screaming and terrified like his passengers. The question is, what does a good life mean to you, or a good death? Most people think that a good death means that they can die at home with loved ones. They can be having their pain and their discomfort managed, have their spiritual values respected, and accomplish what Atul Gawande said: our ultimate goal is not a good death, but a good life to the very end. Now, I have some questions for you at this point, and I'm not going to be able to see responses per se, but I'm just going to let you reflect for a minute. How many people here have a pulse? How many people, I've already asked, have an advance directive? And then how specific is your advance directive? Now, all of that being said, the next question is, when was the last time you updated your advance directive or your pulse? Things change all the time. So if there are any changes, it's time to update your advance directive. If you already have one, it's time to get an advance directive if you don't. How many people here have also designated a medical proxy, documentedly designated a medical proxy? And that being asked, how many of you are actually confident that your medical proxy will abide by your wishes at the end of your life? In an advance directive, it really performs two tasks. The first is it names a medical proxy. And the second, and that's the person to speak for you in terms of it's your medical power of attorney when you can't speak for yourself, but it also creates a living will. And we're going to get into what the issues are around a living will here shortly. Now, the thing to note is that, generally speaking, advance directives are state specific. That means each state has an accepted form that they will allow you to have, and you can download that form and fill out that form for your advance directive. Now, that doesn't mean that an advance directive is not portable, that it won't go to another state. The question is whether or not that advance directive is actually executed on the terms the state you're traveling to requires. And the second part of that is you need to have that document with you at some point if you get into that kind of Nancy Cruzan accident. So the problem is right now, 3 out of 10 people in the US have an advance directive. That's not very high, given the issues that are often accruing when you have an advance directive. If a truck hits you, for example, and you do not have an advance directive, the medical protocols require that everything has to be done to keep you alive, regardless of your condition. Doctors, hospital staff, and the courts will determine who has control over your life. Think about that. Doctors, hospital staff, or the courts will determine who has control over your life at the end of your life if you don't have a medical proxy named. What that goes to is, if you are, for example, a member of the LGBTQ community and you are not in a relationship where you are legally married, then the courts will ignore that and go to either the adult parents or the adult children of yours in order to determine what is wanted at the end of your life. Or they will go to somebody possibly who you may not even want to have as your medical proxy. But because you have not named such, in your advance directive, that person is going to be the one speaking for you in the event of your death. In that regard, then, without an advance directive, you could end up with needless pain and suffering. You could end up with a good deal of family hostility, and you could end up in bankruptcy or your estate in bankruptcy. The advance directives, really, if you look at an advance directive, and those of you that have completed one really understand this, that first of all, advance directives are too binary. It's all or nothing, this or that. It has no context. It forces you and your family to contemplate the worst case without really having any resolution that may be appropriate for you. Also, an advance directive is a legal document, but it's not legally binding. What is legally binding is what your medical proxy says. Finally, there's no national database, and this is a project that Ars Moriendi Project is working on and trying to develop in conjunction with the Coalition of Compassionate Care of California, a national database that allows the recording of documents such as these. In addition, I'm working with an organization called ThanaCare that allows you to complete these online, and we'll get into that a little bit later. However, now the benefits of advance directives, of course, are that they clarify your desires. They can provide context if the advance directive is allowed to address the "it depends" or the "what ifs" issues, and they are the basis for healthy conversations. They can help you qualify. They can also help you qualify your medical proxy. Now, we're going to talk about medical proxies first, and at the end of this part of the presentation, I'll take questions. You got that, Julie? So the question that often comes up is, who is the most important person in your life? That being asked, is it the same answer if you are unable to speak for yourself medically? Who is the most important person in your life when you cannot speak for yourself? You're in a coma, you're in a persistent vegetative state, whether it's figured to be temporary or permanent. Who will be the most important person in your life? It's the one that goes by your wishes. Now, I had a friend, and she at one point had an aneurysm on her heart. And at one point, she was 88. She had an event, so she was actually falling back and going through what seemed like a heart attack. Although she had a do not resuscitate, which is a part of what a pulse would be, and so she did not want to be resuscitated in that condition. Her husband panicked, called 911, and decided he couldn't live without her. So he decided she should have everything done to keep her alive. The doctors came, or rather the EMTs came. They took her to the hospital. They performed open heart surgery on her. And finally, she went through months of recovering. All the while, she was really angry at her husband for having revived her, because now her life was nothing but pain and misery apart from having a loving relationship. Which is to say, maybe your spouse isn't the best person to speak for you when you're alive, or when you're going through a medical trauma. Now, I want to be sure that we have an understanding of the terms. You'll hear the term medical proxy. That is my preferred name of the role being played here. You will also hear medical surrogate or medical power of attorney or your medical agent. They are all the same, so you need not be confused by that. And the medical proxy can be your next of kin. It can be your adult children or your spouse. It can be a family member. It can be a friend. It can be a doctor, but not a doctor affiliated with your provider. And it can be the person who holds your durable power of attorney. That would be the person that holds the purse strings in your estate, handles your checkbook and things like that. Now, your medical proxy has basically 6 powers. First of all, they can request, consent to, or refuse medical tests. They can request, consent to, or refuse medical procedures and treatment. They can move you to a different location. Now, this comes up where there may be an issue where there is a disagreement between the medical facility where you are being treated and what your desires are. And although this is not a completely relevant side of it, if you wanted medical aid in dying, for example, and you're in a faith-based institution, then the faith-based institution has the right to say, we are not going to allow that in our facility. So your medical proxy has the right to say, okay, we're going to move him or her to the facility that it will allow that. They can also request or authorize an autopsy after you have died. They can donate your organs, and they can determine what to do with your body after death. However, your medical proxy does not have 3 particular powers, and depending on your age, some of this is relevant, some of it is not, but they cannot commit you to a mental health facility. They don't have that power. That takes a completely different advanced medical health care directive. They cannot authorize sterilization, and they cannot authorize an abortion. However, in qualifying your medical proxy now, there are really 8 things to consider. First of all, are they legally qualified? Are they over 18? Are they not a member of your healthcare providers, organization, things like that? The second and most important thing, and it goes back to the illustration I made earlier, do I trust this person with my life? Do they know and respect me? Can they separate what they want for me from what I want for me? And am I choosing them because I feel legally obliged? Will they be readily available? That is to say, if your healthcare proxy is in New Jersey and you're here in California and they are very busy and a world traveler, they may not be your best option to be a medical proxy. Really critical, are they good in a crisis? Can they hear and accept the truth even when uncomfortable? How well do they process information? Are they a straight shooter? That is, they're not going to pussyfoot around in trying to describe what's going on and how you feel about it, if you are able to even hear that. And how well do they handle conflict? And the issue of conflict can come up particularly, a classic example, if you look at Jessica Zitter's film Extremis, she deals with several families. She is a doctor herself, a palliative care doctor, and they deal with several families in Highland Hospital here in Oakland, none of whom have an advance directive or anybody that can speak for the patient who is lying there unable to communicate. So I have many people that say, I don't really need to worry about a medical proxy because I have a family and my family will come to a consensus as to what they want to do with me. Well, not if they disagree, or if they all agree that are there in the room and then Sally from New Jersey flies into California and says, no, 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 you're not doing that to my mother. You're going to do everything you can to keep her alive. That's the kind of conflict. But if you name one person and that person is strong in conflict, they have the right to say, no, Sally, we've already determined this and we're going to let mom go peacefully. Now, one of the issues is alleviating potential conflicts, and I just named one. So you use the completed advance directive as, so you can avoid many conflicts, and I'll get into conflicts more later. But one of the things that you can do is use the documents in My Dying Wishes and Advance Directive Essentials to help actually qualify your medical proxy, that you can fill out all the forms, give copies of those forms to your designated medical proxy, and then just sort of quiz them and find out, well, in this case, what would you do for me? In this case, what would you do for me? And you can go through those kinds of issues. That being said, a question can be, how many proxies do you have? Now, you can have a number of proxies if you think about it. You can have your durable power of attorney for finances. You can have your medical power of attorney. You can have a mental health power of attorney. And you can have an executor of your will. Making it easy, let us assume that you are in need of real critical medical treatment, or you need to be moved to another facility, and it's going to cost thousands of dollars to do that. But your financial durable power of attorney says, no, I'm not paying for that out of the estate. That can be avoided, and you can consult with your attorney about how to do that, but that can be one of the potential conflicts that you have. Some of the ways you can do it, however, are naming the same person to have your power of attorney for medical, finances, and mental health. You can have it so that some of your powers of attorney are within the same person. Or you can have documentation stating who may make financial decisions for healthcare for you, so that even though a person has a financial power of attorney in your medical power of attorney or in your financial power of attorney, you can limit that power so that the medical power of attorney has indeed the right to move you even at the cost of the estate. So I'm going to stop there, and I will take some questions on powers of attorney and medical proxies.
We have one question so far, which is, considering current telecommunications, what problems occur when my medical proxies live across the country?
Well, the issues sometimes may be that it helps to be present and view the person, talk to the person, or sit with the doctor. Now, yes, you can do all that virtually, and yes, it is possible to accomplish that. And there are several issues where California is a little bit behind the curve on some of this. And let me give you an example. My ex-wife, still a good friend and the mother of my daughter, is the vice president and legal counsel for the California Hospital Association. During COVID, she called me and said, we have a situation in the hospital where the hospital is trying to get an advance directive from a patient, but we can't allow anybody into the hospital to sign this, to execute it, and nobody, of course, being in the employment of the hospital, can do that. We can't even get a notary public in. So how can we handle that? Well, I had to go through and do a lot of research, but it turns out that yes, even an advance directive can be confirmed by a notary public remotely from another state that allows it, and there are no other options in California, but it's a real convoluted way to have to go around it. There are all sorts of reasons being in person can be the most significant element.
The next question is dementia a medical or mental issue?
Yes. Of course, it is both. But if you go through the book, and I do have that, and Compassion and Choices has some options on this. If you have dementia, but for even a period of time through dementia, there are points where you are legally competent, that it's clear you can recognize what the ramifications are of the disease, and you can sign an advance directive or a medical power of attorney for somebody if you have not already done so. Or if in the event that a conservator needs to be named, by naming your medical power of attorney on the form for your advance directive, it actually says, in the event a conservator has to be appointed for me, I wish you would consider my medical power of attorney to do that. There are all sorts of issues in dementia. In the book, I deal with effectively a chapter on issues of driving, of sexual relations, because once your spouse has had advanced dementia, you really have lost that person in terms of any sense of relationship, and it becomes problematic. You can also, you can do a host of other things.
The next question is, can there be a joint proxy, i.e., two persons fulfilling the role?
The short answer is no. That being said, you can, first of all, when you name a medical proxy, you have three alternatives. Three alternative proxies. You have your principal alternative, the one that is named your medical proxy. You can also name alternate number 1 and alternate number 2. So you can do that. What I would strongly recommend, even in that condition, or in the condition as I raised before, if you have a desire for family consensus, somebody has to moderate that and speak for the family, and that would be the person I would name. And during your time when you can talk to that person, you want to be sure that they will consult with the family or with an alternative person, but it can be problematic.
Well, I think this is a similar question, but it's sort of more elaborated on. Okay. Initially, the question is it possible to have two MPOA, as in first A, and then if not available, B? And then it goes on. My older son is very qualified in all instances, has medical training. He's a CMO, except he is in the USCG and may be underway and very hard to reach for up to 4 months at a time. My younger son is not 100% on all areas, but better than waiting 4 months in a coma. Can the assignment be worded in such a way that if the older son is underway, the younger son becomes the medical proxy?
Yeah, that is available in naming your alternate proxy. As I say, you can have two alternates in a primary, and so if the primary is unavailable, you can default to the secondary. And even if your primary is away for 4 months on Coast Guard duty, there's nothing that says you can't reach him and say, okay, let's designate, let it default to my younger brother, however you want to do that. But there are several ways you can deal with that.
Okay, I think we have another duplicate question here, which is, can you have more than one medical proxy, for example, husband and then a son?
No. No, the short answer is no, but you can have alternates, and as I say, you can put conditions on it.
Okay, another is, will you be talking about how to update an advanced care directive?
Absolutely. And that will be at the end of the presentation. And if I haven't covered it, which I should, remind me. I will say this, and then I will come back and refresh that. Depending on your age, you need to update your advanced directive and even your medical proxy on a periodic basis. And one of the ways that they talk about doing it is the 5 Ds. And I'm not sure I'll remember all 5 Ds, but decade, if a decade has passed and you haven't updated your advanced directive. Divorce, so if you've designated your spouse and you don't want your spouse to be your medical proxy. And in the forms itself, it says in the event of divorce, it automatically defaults to the alternate unless otherwise stated. Dementia, and as I say, I'm not going to remember all 5 just off the cuff, but basically what it comes down to is any change in your life that is significant, including changing your primary care physician or your health organization, then you need to update your advance directive.
All right. Could you please name the documentary you mentioned regarding the Oakland hospital?
The name of it is available on Netflix. It's called Extremis, Extremis. It's by Dr. Jessica Zitter, who I just actually sent something to yesterday and have been corresponding with because we're trying to figure out how to collaborate on something. I'm not quite sure what, but she has a second one called Caregiver that is out. I'm not sure if that's available on Netflix. I would love to be able to do a presentation with her on that. What she started to talk about in that, the idea that she wanted to profile dying at home under hospice conditions. What she found, and ultimately had to change the direction of the whole thing, was the demand on this woman's husband was overwhelming. And it was an exquisite documentary, not too long, half an hour, I think, profiling the problems and the energy drain that it is to be a caregiver at the end of life. In fact, forgive me for rambling a little bit here, but in fact, one of the things that I demonstrate in my book is that, it's easy to say, I want to die at home. But if you have, as I have a friend right now, I still drive a 93-year-old friend to work because his 94-year-old boss won't let him retire. But his wife is dying and he cannot afford 24-hour medical care. He can only afford 12-hour care. Now, he only works 1 day a week, but he doesn't have the physical strength to be able to catch his wife if she falls or things like that. So when you go through your advance directive and talk about things that you want, like dying at home, take particular care in understanding what the ramifications of a desire like that may be. Now, I am a big advocate of the idea of being able to die in peace at home. But somehow you have to consider alternatives. So Extremis and then Caregiver, and she's coming out with a third one shortly called The Chaplain of Oakland.
Oh, I have a comment on this. The Caregiver video, as far as I know, is not available on Netflix, but you can find it online because I've looked into it myself.
Okay.
The next question is, what if a person who is dying adamantly states to their care team that they do not want the person they designated on their advanced health directive to act on their behalf.
A medical proxy is only valid as long as that person who is in care, first of all, cannot speak for themselves. And that can vary. It is possible to have an ongoing medical proxy, but under those conditions, if the person receiving care has been able to cogently state, I do not want this person speaking for me, and the doctors have heard that, they are obligated to follow the desires of the patient. The patient can always override the advance directive or designation of a medical proxy.
Next question is, do you have electronic forms for your Advance Directive Essentials?
I mentioned earlier that I am working with ThanaCare, which is an organization out of Los Angeles that really does allow for advance directives to be posted electronically, but they are the basic advance directives the way the doctors want them. So Sam Madison is the guy I'm talking to. He's the COO of ThanaCare, and we're trying, he just got copies of the book, and so I'm going to go through with him and see how we can perform that electronically. That is critical to the national registration. So the short answer is today, no. Soon, I hope so, maybe within a year. I will certainly let people know if that's the case.
Can your medical proxy have you moved out of the hospital to home?
Absolutely.
I think that's our last question for now.
Well, let's go on then, and let's talk a little bit about living wills. And this is going to be a little bit in the weeds. We'll see what we can accomplish here. A living will is that part that says, this is what I want. And in determining what a living will is and what you want, let me be clear. First of all, a living will is your preferences generally when you cannot speak for yourself, but it also goes to death and dying, possibly. As I said, the medical proxy has the right to figure out what to do with your body post-death. In California, you have the right to life-sustaining treatment. That's true anywhere you go in the country. You have the right to withhold treatment, including nutrition. Now, if you can't speak for yourself and you don't have a designated medical proxy, this becomes problematic. This is the Nancy Cruzan case. You have the right to comfort care, including palliative sedation. Now, palliative sedation is a contextually legal problematic issue. What you come down to in the legal fictions of healthcare and like so many other legal fictions, palliative sedation means that you as a patient are in such pain that the only way to get you out of pain is to put you effectively in a medically induced coma. Well, if you're in a medically induced coma and you've already said you don't want artificial nutrition, that means you're going to die. Euthanasia is illegal, although palliative sedation is legal. The idea is that the doctor does not intend for you to die. As so much of the law is centered around it, intention is a lot of the issue. There are all sorts of other stories that go on with this, but you have the right to palliative sedation, and then you have the right to hospice. One of the things to note about hospice is that, unfortunately, many people view hospice as giving up. And that is really problematic. The average hospice stay is between 3 and 10 days. You have the right to hospice for 6 months, and it will be funded by Medicare. So if you want palliative care, but not hospice, you're paying for it out of pocket. If you want hospice, it'll be paid for by Medicare for 6 months. Now, the unique thing about hospice is that oftentimes it actually, first of all, improves a person's quality of life near the end of their life. And people can graduate from hospice and then ultimately re-enter it again when things change. But as a friend of mine, Susan Barber, has talked about, even in hospice, people may be in hospice, but what it really requires is that they're also on dialysis and they have to leave their home, but they are mobile and they can go do things, but they're still in hospice. Not a problem. That is legal and acceptable and really something people need to consider. It is not giving up. It is simply changing the medical care protocol. You also have the right to voluntarily stop eating and drinking, VSED. It is the only legal form of suicide in the country. Now, I'm going to use this term very advisedly, but when particularly a terminal patient decides they want to stop eating and drinking, they still have the right to palliative care. Now, stopping eating and drinking is not as painful and problematic as you might think, but it is something that is available. Now, 2 stories, if I may, about that. First of all, I had a friend, Erica, who was probably the closest friend I've had in a long time. She was 96. She spent 3 years in bed. She was in hospice, but she was paying for hospice because she'd been 3 years in bed, much of it during COVID. And so we talked about alternatives for her to let her life go naturally. And I'd mentioned VSED. And she said, well, I don't know, but I get so hungry. Okay, well, you don't have to do it. Another gentleman who, Fran Johns, is a woman it would be helpful to know under some point, but she wrote a book called Dying Unafraid, and she now helps people with VSED and the like. And one of the patients that she had and was caring for said he wanted to voluntarily stop eating and drinking, except that he wanted a shot of whiskey every night. And the medical staff said, you realize that if you have the shot of whiskey every night, you're actually going to extend your life. And he said, yeah, but it'll be so much better. Finally, my father today is in hospice. Now, he doesn't want to be in hospice because he thought hospice was boring and it was giving up. But when my sister, who is his medical proxy, said, so Paul, do you like the woman that comes in and cares for you, especially a couple of times a week? He goes, oh yeah, she's wonderful. Would you like that to continue even though you don't want to be in hospice? Oh yeah, I'd love that. Okay, we're going to call it hospice, but we're not going to tell him that. Because hospice was really what he wanted. Now, he, on several occasions, has said he wanted to stop eating and drinking, and he has taken steps to do so, or he'd go and eat very little. He's lost about 30 pounds. He's 96 now. And then 2 days ago, he said, I want to eat again. Okay. So there's nothing that says you have to do one thing or the other, or you can't change your mind. You can always change your mind. The final element is, of course, medical aid in dying. Now, I used VSED as being a legal means of suicide in the aid in dying community, and I agree with them 100%. In fact, I was a Compassion and Choices volunteer. It is not physician-assisted suicide. Medical aid in dying in California is a situation where you can get a lethal dose under very specific conditions. You have to be terminal with 6 months or fewer to live. You have to be mentally confident. You have had to make a statement to your 2 doctors as to your desires, including a written statement. And you have to be able to administer that medication yourself. Somebody cannot give it to you. You have to actually be able to eat it or ingest it whatever way is necessary, including a plunger through the rectum. But you have to be able to administer it yourself. Now, that being said, legally, medical aid in dying is not suicide. You have, your death certificate has to say you have died by the terminal condition that caused your death, not medical aid in dying. That your insurance company has to pay the benefits that they would have paid had you just lived your life to the terminal end. And nowhere in any conversation is the element of suicide to be part of that. It also raises, though, the specter of what facility are you going to be in when that happens if you're not at home. And as I say, my ex-wife was a member of the California Hospital Association, and she wrote part of this legislation, which was the very legislation that said doctors and physicians are not required to do this. They can opt out, and it's up to the patient then to figure out how to do it. Anyway. So advance directives are way too binary. It's really an all or nothing problem the way they're written out. And we're going to get a little bit into the weeds here, but we're going to take a look at some of the forms. Now you can go to, and I know you can't read this. I recognize you can't read this. I am just showing you forms, and I'm going to give you ideas as to what this is. Basically, it's a 4-page form. You can download it from my site, arsmoriendiproject.org, and get any state's authorized form through my website. You can also go to AARP or the American Bar Association or Compassion and Choices and get exactly the same information. Now, if you look at this, it's telling you in the red circle that you have the right to make decisions about your health care and name somebody who does that. And a form lets you do either one of these. So if you decide not to name a medical proxy, you don't have to. Or if you decide not to have a living will and only name a medical proxy, you can do that too. It also lets you talk about the donation of your organs, your primary physician, which is why you want to update it with your primary physician. And you can complete or modify the form any way you wish. And we'll get into that specific in a bit. So in your advance directive, this is the form for the designation of your medical proxy. So you name your primary proxy, you can name an alternative proxy, you can name a second alternative proxy, and then you can talk about exactly what the authority is. And so this is the place you can modify the form to say, if so-and-so is on leave in the Coast Guard, or rather away in the Coast Guard, that then revert to alternative number 1. And then you also have the right to say this medical proxy can speak for me even while I'm alive and cogent, or only when I cannot speak for myself. Then as we go down here, you'll see I mentioned earlier nominating a conservator, and that is to say that if for whatever reason a conservator needs to be named, that you can nominate your medical proxy there. Now we get down to the end of life decisions. It's a very small portion of the form. Here it is. If you fill out the following form, you may strike out any wording that you want or don't want. And it really is just, I want medical aid in dying. I'm sorry, I misspoke. I want to choose not to prolong my life, or I want to choose to prolong my life. And I want relief from pain in the following conditions. That's it. That's the whole living will, except for item 2.3, which is other wishes. Now, if you go into If you go into My Dying Wishes or Advance Directive Essentials, you will see that it really is a book, and the Essentials particularly, is really a book of forms. These forms are all addenda. It's not an advance directive. There is nothing in these books that is in itself a self-contained advanced directive. What it is a series of forms to say under item 2.3 under other wishes, see addenda attached. And in that, then you can go through all sorts of elements about what you want or what you don't want. Then this part of the form is your organ donation form. This is the naming of your primary care physician. And today in institutionalized healthcare, that can be problematic and change annually. If it does, you need to change your primary care physician. And then in part 5, this is what is most critical if you're traveling to other states or even within the California. You need to sign it with all the appropriate information. You need to have 2 separate witnesses sign it, and they need to make an additional statement saying that they are who they say they are, etc. The alternative then is that you can have a special witness, or if you're in a retirement home, for example, you may need, or more particularly a nursing home, you need an advocate or ombudsman statement. All of that being said, you can also simply have a notary public. You don't have to have all the rest. What you need to be careful of is if you're traveling across state lines and going to a different state, you need to be sure that their attestation elements, witnesses, notary public, etc., are compatible with what you have. Otherwise, you may want to have it re-executed on that basis. Now, some of you said you have a post. A post is exactly a doctor's order for medical treatment. Really, it's a combination of a do not resuscitate form and or wanting full medical treatment. And it's really most important for EMTs. When 911 is called, you have the right to have them obey a post. Now, I said much earlier that an advance directive is a legal document, but not legally binding. And this is critical. An advance directive is a legal document, but it is not legally binding. And by that, I mean, when the EMT comes and they are ready to administer CPR or whatever other medical treatment may be necessary, your medical proxy can't run to the EMTs and say, no, I have an advance directive. You don't need to revive him. They are going to ignore you. But if you have a post, that is a medical EMT treatment binding document. If you have that and can wave that in front of them, then you're not going to have to worry about them reviving somebody like my friend who was revived by 911. Now, the other thing about a post, unlike an advance directive, is normally a post, depending on the state you're in, is lime green, bright fluorescent lime green or bright pink. The California form, I believe, is pink. In fact, I know it's pink. But that form, if it's in your house, will be attached to your refrigerator, and the EMTs will know to go directly to your refrigerator and look for that form. Or in a retirement home, for example, it will be either at a desk or in Lake Park, where I was a chaplain, inside the bathroom mirror, but people know exactly where to go to find out what your treatment desires are. A post is signed by a doctor. It is a legally binding medical determination. It's a medical order. However, even a post will refer to an advance directive. and it will say your advance directive is dated here. It will name your healthcare agent. Now, the post will not name your healthcare agent. It will name the healthcare agent in your advance directive. So if you haven't named your healthcare agent in your advance directive, then this is irrelevant. And what is most critical here is, and I won't read this, I'll read this to you, but do it while we're here. Medical protocols require that the doctors have to go through a search procedure, if you will, in order to determine who can speak for you in the condition where you can't speak for yourself in the hospital. Now, I have people who say, well, I want my doctor to determine that. Well, no, they're not going to do that. That is not what they're there for. What they will do is try and figure out, or your healthcare provider generally, they will try and figure out who your legally recognized decision maker is. And if they don't have a legally recognized decision maker and they are not orally told by you, then they will designate a surrogate, and it will be in a sort of protocol level. Your spouse or registered domestic partner, if you're a parent of a minor, or the closest relative, or the person whom the patient's physician believes knows best what the patient's best interest is and will make decisions in accordance. And what's missing there, of course, is, if you're not a spouse and you're in an LGBT relationship, and I have two siblings who are in LGBT relationships for 30 years, and before they legally got married, they would have had no rights. Their spouse and their partners would have had no rights to determine their medical proceedings under even a post. Now here, and this is true with anything, it is recommended that a post be reviewed periodically. The review is recommended here when the patient is transferred from one care setting or care level to another. So if you've moved from ICU down to more general care, that's fine. Or if you've been moved up to ICU, then that makes a difference, and the post may be revised. If there's a substantial change in the patient's health status, or the patient's treatment preferences change. So again, you have the right to say at some point, no, I don't want that person as my medical proxy. I don't want artificial respiration, or no, I do want artificial respiration. So an advance directive, particularly if it's detailed enough to have the addenda in it, deals with the "it depends." Now there's a nuance here that I think is important. Lachlan Forrow, Forrow, wrote an article in 1994 called "The Green Eggs and Ham Phenomenon." And he really based it on the book Green Eggs and Ham. So the article elucidates a problem with basic advance directives and the approach by which the doctors have them completed. Unsurprisingly, for most doctors, completing an advance directive on the fly in the hospital is trying to get a box checked. It is not listening to the patient. And in that regard, then, as they're prescribing whatever they want or trying to advise a person about their rights for medical treatment, the person will say things like, I don't want that. Under no circumstances do I want artificial respiration. And if you look at the COVID crisis and the number of people that went into ICUs and needed artificial respiration, the question becomes why and under what conditions. Too often in the green eggs and ham phenomenon, doctors aren't listening to their patients. They're just advising patients without context. And so the patient, like in green eggs and ham, said, no, I don't want that. No, I don't want that. Then the more they're pushed, the more they don't want it. However, if the question is rephrased, then it becomes one of, okay, let's talk about your quality of life. If you found out that you could be completely recovered if you went in and had artificial respiration and or inserted a feeding tube and the like, and you could walk out of the hospital with 80 or 90% of your pre-medical emergency facility, how would you feel about that? Oh, well, under those conditions, I think I would do that. Well, that changes the whole green eggs and hams perspective. The other side of that is, okay, you've said you want this and you want everything done for you medically. And I hate to tell you this, but you only have 3 or 4 days to live or 3 or 4 weeks to live. And there is nothing medically we can do for you that will increase that or improve that. What would you like? You still want ICU? Oh, no, I'd much rather go home. One of my favorite stories is about Ken Wilber. Ken Wilber is a spiritualist. You may be familiar with him. In his book, Grace and Grit, he talks about the 5-year struggle to have his wife find some sort of treatment for her breast cancer. And after 4.5 years of going through every kind of iteration they could figure out, they end up back in the doctor's office, listening to the doctor. And the doctor says, well, I think with aggressive medical treatment, we can give you 6 more months to live. And Wilbur, completely exasperated, says, well, what in the world if we just take her home and let her die peacefully? How long will she have then? Well, probably about 6 months. And what's the point? So advanced directives can be supplemented with value statements and questions like, what is the quality of life that is critical for you? What are your spiritual issues? What are your cultural values? What is your bucket list? And by bucket list, I don't mean I want to go hike up to Machu Picchu. It's, well, I want to live past Christmas so I don't die on Christmas Day, which is what my ex-wife's father decided. And he died on December 26th because he didn't want his family to celebrate Christmas and his death on the same day. I want to see my granddaughter graduate from high school. I want to see the sun come up tomorrow. Now, one of the advanced directive forms that you may have heard about is 5 wishes. And a lot of what I have done is predicated on 5 wishes in some level, but is greatly expanded from what 5 wishes is. But 5 wishes starts with the basic advanced directive issue of who makes care decisions when I can't. Then it's what kind of medical treatment do I want or don't want? How comfortable do I want to be? And this is where it begins to deviate from your basic advanced directive. How do I want people to treat me when I'm in the dying process? And what do I want my loved ones to know? And if you go through the forms on My Dying Wishes, you will find that gets expanded even more. And there is a whole section on what your cultural desires or needs are, what your spiritual desires or needs are, all those kinds of things. And so an advanced directive may also say, my health today and what care contingencies do I want today based on my health? How comfortable do I want to be? How I would like to be treated, all of those. What I want my loved ones to know. How would you like to be remembered? What your funeral and memorial arrangements may be. And particularly, also what I want to be done with my body and remains. And particularly from a Buddhist perspective, how long do I need, in a Buddhist perspective, how long I want to lay in state in the residence. And one of the things to note here, I know I'm deviating a bit, but one of the things to note is there is nothing in the law that says you have to have a body removed from the premises immediately. So whether you're Buddhist or in the case here, my landlord died. I live downstairs in a single family house. And a year and a half ago, my landlady, also good friends, I've known them for a number of years, almost 20. And one morning, the day after Easter, Annette comes downstairs and says, "Rick, help, it's 6 a.m. Rick, help. Lloyd has fallen out of bed and he's medically unresponsive." Well, at that point, it was a matter of he died. Now, he hadn't filled out an advance directive. They spent a half an hour on a machine trying to do CPR because even though we all knew he was dead when he hit the ground, that's what they had to do. But once they left, I said, "Annette, now is the time to be able to say goodbye." And as the family began to show up, he still lay on the floor. We dressed him some, but he spent several hours, and it could have been 2 or 3 days there in state, if you will, on the floor. And so I called the funeral home and said, "You can come pick him up, but we need some time," and set an appointment so that people could say goodbye.
Yeah, I do have comments on this.
Go ahead.
In my experience, and I'm not sure about states other than California and Oregon, and you should check, but I do believe you can keep the body for an extended
That is absolutely true.
days, certainly. This is for more than one reason. One, in that it allows the consciousness time to exit the body. It allows the family to sit with the body. It allows for prayers and practices to be done in the presence of the body or nearby. And it's highly recommended for this to happen. There's other questions coming up that pertain to this. I don't want to take a bunch of time, but I will say.
Well, let's do that. Let's go ahead and do that.
Say one, TLC's manual instructions for the transitional state really cover this ground. And we also have a transitional state forum for groups that in detail goes into all the questions that you might have as a Buddhist pertaining to this particular topic. So I wanted to mention that. Do you want to go ahead and have me read a couple of more questions?
Yeah, please go ahead. Yeah, we're moving on to another section.
Do providers such as doctors, hospitals, EMTs, etc., actually check the state registry to see if an advance directive is on file?
No. Generally not. This is part of the training that the Coalition of Comfort Care in California is working on, is that kind of both database and getting doctors trained enough to know that there's a database. And the database is still sort of in beta form. And it's what I'm trying to work on with advanced directives more generally. So no, they don't generally, and they should. And EMTs are not going to look for it. They're not there to do that. The only thing they're going to look for is a pulse, and the pulse better be a bright form on a refrigerator, because they don't have time to do anything else unless the dispatcher can say, this person has a pulse.
There's another question pertaining to 5 wishes. First, people in our community use this, and can addendums be made to this? And
yes.
With that, a person says, I would like to change my healthcare agent. Can an existing advanced care directive by crossing out information or by adding an addendum so that the entire form doesn't need to be rewritten? Mine was created with an attorney when my late husband was part of it, and I'd like to make changes, but cannot afford to involve an attorney again.
It's sort of like with a will. Not speaking as an attorney here, be clear, I am not an attorney, but that being said, speaking as a person involved in advanced care directives, the first issue is how many copies of the directive are out there? And can you get them all back, or let people know that it has been voided? Because once you have done that, it has to be voided. I can say unequivocally, once you have made changes to the advance directive, it will have to be re-executed. Now, in order to do that, I would be inclined, for example, to take a photocopy of my advance directive and a clean signature page and just put a new and initial also the changes, and then put a new dated execution page on the advance directive. I might even include the original execution page with a big X out and the new page redated behind it.
Okay, I also want to mention that on TLC's website, we have an excellent video called Legal Matters at the End of Life that goes deeply into every document you need. And it's very organized and succinct, and we really recommend it. So you can check that on our video page. The next question is wanting information about organ donation and how time is of the essence, and also pertaining to Buddhist practitioners, why this is a very tricky procedure, in that if you're hoping to have transference of consciousness, or the person is an advanced practitioner, and we never know who's an advanced practitioner, their body needs to stay in state until consciousness has exited the body. And generally, I believe that organ donation needs to be done very quickly after death. And you can clarify that for us. Thank you. I think the question,
it depends on the organ in part, I would guess.
Yes, it does. Usually, at least my education has taught me that usually they need to take the organs fairly quickly.
Yes, that's true.
And as long as the consciousness is not assuredly left the body, this makes it very challenging for the Buddhist practitioner who wants to have a smooth transition. You don't touch the body until after the consciousness has left. So any kind of procedure, incision, movement is to be avoided as much as possible. So that would indicate that organ donation, unless you are certain that you can have POA done, which is the transference of consciousness practice, or that you are an adept and you will be leaving immediately through your own accord, you're putting the process of the consciousness leaving the body into a certain amount of jeopardy. So that would be, I think, the answer I would have for that.
I would agree wholeheartedly.
Okay, and then the question again, are you saying that a post can be amended or changed by the person who wrote it? Or do you need a brand new one?
First of all, the person who wrote it is not the person that is going to need medical treatment. The person who writes a post is a doctor.
Oh, in my experience, I wrote my own post and my doctor merely signed it. All it would need is the doctor's signature.
Okay, but the doctor's signature, by the doctor's signature, is basically that it's under his or her authority. So you can't just change it. You have to change it and get it signed, because it's a medical order.
Right. Yeah, you would have to fill out a new one.
basically, that's what your doctor would require, I'm sure.
Yes. And this is a question I'm not totally clear about. The person saying, with a pulse, it seems to me that it depends. What if I am simply choking? What if I just died? What if? Do the EMTs check to see if I am dead? My experience is that whether your heart or breath has stopped, the EMTs are still required to do CPR.
And generally speaking, it is not the CPR.
Is that incorrect?
It's not, generally speaking, it's not the EMT's role to determine whether or not you're dead specifically. However, they are in contact these days, technologically, they are in contact with a medical authority who can pronounce basically over the whatever, Wi-Fi, computer, what have you. That being said, yes, they are medically required to do whatever they can to keep you alive. As I say, with my friend Lloyd, who lived upstairs, the woman who, Lloyd's wife, had come to me and asked for copies of the book so she could give them to her dying sister up in Quincy. So I was kind of surprised when she had done that, and then when Lloyd had died, that the EMTs came and said, does he have anything in the way of a pulse or a do not resuscitate or anything else? As they have strapped him up to, I don't know if you've seen these now, but instead of just a manual CPR where you're just pumping, it is now a machine that you strap around the body, and then it just automatically does a full pounding on the chest. And so this thing is going off, and every 10 minutes they try his vitals again, and ran it for half an hour because the EMT came to his wife and said, does he have anything like a pulse, do not resuscitate or anything? And the subtext of it to me sounded like, he's dead. I have no question he's dead, but we'll keep this up because, we have to legally. And she said, no, we've never had the conversation. I just you have the books. We've talked about this, and you never talked together about what you want at the end of life. So I don't know if that completely answers what you're asking, but.
Thank you. There are more. Shall I go on?
Sure. Yeah, I have very little remaining that can't be addressed as we go.
Okay. I plan to move out of state in 2024.
Mm-hmm.
Can you repeat what I need to do with my advanced healthcare directive?
In short, the state where you're moving, take a look at their forms. And again, you can download any given state's form either on Ars Moriendi Project.org or AARP or ABA or Compassionate Choices. Take a look at that form, because what is critical is not so much what is said, but how it's executed. What do they require for signatures? What do they require for notary? And maybe at worst, what you need to do is get it re-notarized for the local notary.
Okay. And if you don't mind, after I read this, I have a comment.
Okay.
It says, it seems that most hospitals want to move a body out of the room as soon as the person has passed. What rights does a medical proxy have to insist that a person stay still to allow prayers for at least 12 to 24 hours so they can be performed on site? And in my own experience, the medical proxy has nothing to do with the hospital policy. Hospital policy dictates that usually it's a half an hour or less because they want the bed. So the body will be moved to the morgue. There have been exceptions to this, if some glitch or some unusual circumstance arose, but generally you can't do anything about this, which is another reason it's good to have the person at home, if at all possible.
Yeah, I agree completely that if it's about not moving the body, you had better, at the very minimum, I think the only thing you're going to be able to do is agree to pay rack rate, if you will, for the room while after the death, because yes, it's like any place, they want to turn it over. They need that bed and they need it right away. So yes, you're absolutely right, Julie. It is extremely problematic and highly unlikely that there's anything. And certainly from a legal standpoint, there's nothing the medical proxy can do.
Right. Are the forms in both of your books related to addendums to advance care directives and not about actually making one? If so, do you recommend using the 5 wishes document with addendums added as needed?
That is completely up to the individual. The way that My Dying Wishes is formatted, there is nothing in that there's nothing in 5 wishes that is not covered in My Dying Wishes. So the whole idea is that, and if you go through the books, and especially just take a look at the Advance Directive Essentials, for example, this is just the forms. You can go through and find everything on an expanded basis to what 5 wishes offers you. And I would dare say it goes deeper and covers more territory, especially when it comes to trying to qualify your medical proxy. I would recommend you have them fill out the forms independent of you and then compare what you have said to what they have said and then talk about it from there. Now, all of the forms are available in both books, but Advanced Directive Essentials is just the forms. But there is no reason, and you have to pay for a 5 wishes form. There is no reason to use 5 wishes if you have the state's form and just say, see attached addenda.
That's the last question we have right now.
All right. So as far as anything else is concerned here, then to me, one of the most critical ways to use these forms, in addition to, as I just elucidated, is in the qualification process. I opened with the fact that talking about death is the second most difficult, feared thing in society for the most part, after public speaking, ironically. And so even when people have filled out their advance directives, oftentimes they have not actually had the conversation, and this is hugely problematic. I have friends, and it's interesting that it goes both ways. I have friends who are in their 80s who want to have the conversation with their children, and it is so common for the children to say, no, oh, Mom, I can't think about your dying. I cannot imagine what it would be like without you. I cannot talk about this. Or conversely, the kids who are recognizing Mom or Dad are growing older and are in need of tremendous medical care and really don't know what they want. Say, Mom or Dad, we need to talk about what to do if, when you're getting, I don't know, you're getting older. I was sitting, well, let me preface this. So I told you earlier that I drive a 93-year-old man to work every week, and his wife is also 93, and she is approaching death very rapidly. They cannot imagine what death will be like for either one of them, and they do not want to talk about it. They won't talk about it. Now, he will occasionally mention to me that he recognizes she's dying, but he cannot have the conversation with her. She has not got the self-awareness to be able to say, it's time for me to reevaluate and figure out what I can do to be at peace. And this is what I want to do and how I want to do it. And so they won't talk to each other about this. And part of the issue came up when he takes me to a bar, or to a restaurant rather, down to Skates in Berkeley. And we're sitting there and having dinner, not with his wife, not there. And I at one point said to him, my father's decided to stop eating and drinking. That he's done with life. And he literally breaks down in tears and says, I cannot imagine doing anything like that. I am going to live until for years and years and years. And he won't even acknowledge that death is imminent for somebody 93 years old and as frail as he is. I have to drive for him all the time. He's lost his license. He just doesn't have the wherewithal to do much of anything. So having the death talk is admittedly a very difficult element, but it needs to be had. And so the forms can be used to help motivate and illuminate some of what you want. And obviously you need to have your death talk with family. You need to have it with your spiritual advisor. Questions, Julie, like you brought up earlier regarding POA and the ability to have consciousness transferred and transplants, those are the kinds of things that need to be discussed. You need to have this conversation, and often they will ask for your advance directive by your physician or healthcare organization. And then if you have a mental health professional, they need to know as well. And you need to be able then to communicate your wishes, to actually, if you've completed it, go through your advance directive, and most critically, I would say, uncover objections. Because when you find an appropriate healthcare or medical representative, your proxy, that's what you're going to have to learn first and foremost. And I cannot stress this enough. Also, if you're having the conversation, and I have all the forms in the books to deal with these kinds of things, as Five Wishes doesn't really deal with post-death issues, but after I've gone, I would like to have my body, and you can go through the whole host of things. And these days, the options are far more significant than you can imagine. You want to have your body donated. My father wants to have his donated to University of Washington, and you go, well, he's 96. Why would they take him? They want him. They want anybody. They need cadavers. You can have it buried. And where would you like to have it buried? You can have it cremated. You could have it composted. You can have it aquamated. You can have it eco-potted. There are any number of things in the state of California, and the options are getting increasingly larger throughout the United States. And obviously, if you were in a country like India or Tibet or places like that, you may end up either being cremated or at one point being fed to the birds. The other thing that is covered in these forms is how I want to be remembered or more memorialized, if in fact that's what you want. Whether you want a funeral or you want a memorial service or you want some sort of marker or a bench or whatever else. And then this is an expanded version of what Five Wishes offers. It says, as I approach death, I would like the following to be available. I want people around me, or I don't want anybody around me. I want music playing. I want hymns sung. I want my pets near. And most critically, what I would like my loved ones to know. And then the various other forms you can find are in the event of dementia. And so you have all sorts of addenda that are available in this book. The treatment desires depending on prognosis. And if you look at the book, you know, an advance directive is an all or nothing. If you look at the book, you have the option to say, if my likelihood of survivability and living the quality of life I had before is 80%, do this. And it is a sliding scale. So if it's less than 2%, do this. What my general attitudes toward treatments are, but if in the green eggs and ham theory, recognize that it may change depending on how it's presented, including do not resuscitate rules. You have pages and pages in the original book of spiritual, religious, and cultural considerations, dementia provisions, visitation authorizations. If your primary relationship is not somebody who is legally recognized, and this goes back to the LGBTQ issues, you need to complete visitation authorizations if you're in the hospital. The conditions under which you might want to be transferred, and specific desires as death approaches. That is the kind of environment you want. There are all sorts of things, including letters to my physician, which the Stanford Letter Project has, and various other things about what I want my loved ones to know and what to do with my body. And funeral memorial desires again. Now, I want to say something here in that Caleb Wilde is a funeral director and a very good author. He's got some good books, which I would recommend you read. But one of the things he points out as a funeral director is the dead don't care. And so his response is to that, do whatever makes you feel good. Well, to me, what's critical, and this kind of goes to a chaplaincy mental health side, no, the dead don't care, but the living want to know what the dead wanted. If the living don't know that, in my friend Erica's case, that she wanted to have her ashes spread at Sea Ranch, that she wanted to be cremated, yeah, she may or may not care, but that's also a consciousness question from a Buddhist perspective. But the family really wants to know, generally speaking, that they're doing what mom or dad wanted. So it may seem immaterial, but I think it's critically important that these kinds of issues are addressed. So just to review here, it's important to review your documents periodically, annually. It may be, depending on your age, critical. A change in medical personnel, a change in the durable medical power of attorney, a death of a loved one. That's the other one, one of the Ds. The diagnosis and death are the other two Ds I mentioned before. And or any significant health decline. And then once you have completed your advance directive and got it appropriately executed, you need to distribute your document, first of all, of course, to your medical proxy, to your attorney, to the holders of other powers of attorney, so that those conflicts can be avoided, to basically any of your loved ones and anybody else who might need to know. I would also argue that you should maintain a travel copy, so that if you're on vacation, and whether it's in the form of a USB stick or an actual hard copy, I know people that keep them in their glove compartments, so when they travel out of state, that copy is available. And what's critically important to recognize is this document needs to be public. It's not something that goes into a file in your attorney's office and nobody knows about it. That may be your will, but it is certainly not your advance directive. So I will take any other questions at this point.
I don't believe we have any more at this point. There was one question I answered on a chat about sky burial. someone asked if there's anywhere legal to do sky burial. I think Tibet, certainly, which is actually now called China. But I feel that most likely you would have to be a citizen. And as a US citizen doing that, I think you would probably come into some red tape. This is something you could research on your own. It's certainly not legal in the United States. And you can have sea burial, and you can have open air cremation done in a couple of spots, including the Crestone End of Life Project.
Mm-hmm.
But I'm not sure. You just have to research that on your own. I have never heard that sky burial was legal in the US.
Well, one of the things to note about sky burial, if you have ever read the books by Caitlin Doughty.
Oh, yes.
She talks about sky burial, and one of the problems with sky burial has become that, particularly in the Hindu tradition, they'd have sky burial, and they had a particular facility for it, and so the vultures could come and get the body. And yet, the birds have died off, or they are no longer able to actually have the kind of sky burial that is important and critical to have the full ingestion of the body or removal of the body. So even in culturally appropriate places, it has become problematic. Caitlin Doughty also did an interesting sort of documentary, both on composting. You can go to her website. She does one on composting, but she also does one about feeding your body to wildlife. And in this regard, what happens is the body is appropriately, I'm not even sure what word to delicately use here, but it is basically mashed up and pureed, if you will, and then incorporated into food that goes into animal feeding blocks, and she does a whole documentary on that. One of the things that I have talked about in my own death is that I would like to be either aquamated or composted, and then combined with concrete and put into a sort of dome, kind of open dome, taken out to sea and be used as the seeds of a reef. So there are all sorts of options that you can do along those lines.
TLC also has a really excellent video on alternative interment on our website, and I believe it's also on the free videos page and YouTube, our YouTube channel,
right,
which it really covers a lot of ground. There are a couple of more questions now.
Well, I'd seen a question in the chat. Let me just say this. Somebody said they type in arsmoriendiproject.org and it goes to arsmoriendi.com. That's because I originally had formed arsmoriendi.com, and so arsmoriendi.org simply opens.com. So that's the right location. The corporate legal name is arsmoriendi.project.org.
There's a question. List you just showed of who to give the completed documents to and where to keep them available on the website or in your books?
It is in my books, and there's a checklist in the back, but and various other places also allow or show you where to keep them. But here is the list again: medical proxy, an attorney, your holders of other powers of attorney, your loved ones, anyone who might need to have a copy, a travel copy, and an obvious place at home.
There's a question. If someone would like to know if you could repost the second to the last slide that you showed.
As far as review?
I would assume, yes.
you should have your documents reviewed periodically, annually. Change in medical personnel, change in durable medical power of attorney, the death of a loved one, specifically a death of a loved one that may be involved in your potential end of life issues, a change in your diagnosis or a decline. Now, I bring this up particularly because I sat down several years ago with my parents and said, well, let me go through your advance directive and your post. And I looked at it, and this was probably 2017, 2018. And as I'm going down it, Dad, this isn't your doctor. You don't want this. You were long past that desire. And I finally looked at the date of the form. It was like 1989. They hadn't updated it in nearly 20, 30 years. So updating it is critical. Well, and just in closing, this is discussions about advance directives and dealing with the issues of death and dying can be one of the most difficult things you can do, especially when you're trying to talk to your family about it. And so a lot of the basis of the forms and all of the advance directive addenda that I have provided really are as important to use as discussion vehicles as anything else. You want to avoid the fights with your family. You want to avoid the chaos that may result when a medical emergency comes up. And most critically, this isn't just about being older and in physical decline. The whole idea of if a truck hits you is what's particularly important. Nancy Cruzan was 25 years old, and she was beyond the care of her parents, and she could not speak for herself, and there was nobody that was legally allowed to do so. So if you look at her gravestone, it says, died January, I think, 11th, 1983, and then at rest in, I think, December 26, 1990. But that whole intervening year was her lying there in a persistent vegetative state and nobody able to do anything. Have the conversation, please. Fill out an advance directive. Talk to your kids about it. Talk to your parents about it, but get it done. The fact that only 30% of people have an advance directive, and that includes elderly people in that 30%, says that there is a lot of work to be done. So thank you for anybody that's willing to do that and making not only your life, but your family's life more complete with the knowledge.
May I be a guard for those who need protection, a guide for those on the path, a boat, a raft, a bridge for those who wish to cross the flood. May I be a lamp in the darkness, a resting place for the weary, a healing medicine for all who are sick, a vase of plenty, a tree of miracles, and for the boundless multitudes of living beings, may I bring sustenance and awakening, enduring like the earth and sky, until all beings are freed from sorrow and all are awakened.